A patent is a government license that is granted to a patentee who has generated an invention, and the patent is granted for a period of 20 years beginning from the day the application for the patent is lodged. It is granted in exchange for the patentee to publicly disclose the information about his invention. Inventions, we can regard them as technical devices or machines or a composition or combination of methods of matter, of processes, if you like. It can also be regarded, we can also include medical technology, or pharmaceutical technology, or pharmaceutical products. But what is important is that such invention must be new in the sense that it has not been publicly disclosed anywhere. They must, their creation or their production must involve an inventive step. In other words, it must not be very obvious to the eyes of experts in the field. And the invention must have utility in the sense that it can be applied in trade, in industry, or in agriculture before they can qualify as invention under the law in South Africa. But I need to also state that there are some items, some subject matter that are excluded from being regarded as invention under the law. For instance, things like discoveries, like scientific theories, like mathematical methods, like computer programs per se are excluded from invention, except they form part of a technical process. Also, even when a subject matter is not excluded from being an invention under the law, the invention may not find protection if it is contrary to, if it promotes public immorality, if it promotes immorality, or it is contrary to public policy, it is contrary to natural law. Some other items that are excluded from patentability would include plants and animal breeds, that is new plant and animal variety. Other things that are also excluded would be medical treatment process. Also, you can find that under the law, literary works, artistic works, musical works are excluded from patentability. And the reason for this is that these works find protection under copyright law. Okay, things like plant variety, animal variety also find protection outside, patent law, and that's the reason why they form part of the excluded subject matter, for protection. Patents in South Africa are protected under the Patent Act. And what that means is that patents is regulated statutorily. So there is nothing like customary patent or customary law of patent. There's nothing like common law patent or common law of patents. It is purely statutory and regulated by the Patent Act. To protect your invention legally, first you must make sure that when you create the invention, you keep it secret, you do not publish it, you do not make it public, because like I said before, patents must be new. Okay, so you must make it secret, you must not disclose it publicly. Two, you then need to get it registered by the Companies and Intellectual Property Commission, the CIPC. There are the procedures for registration of your patent and obtaining of patent is governed by the Patent Act, but if you and this information are explained in very simple terms in the website in the CIPC's website. A patent will generally last 20 years from the date of the lodgement of the application, not the date of the grant. because the date of the lodgement of the application is the date the invention is disclosed to the public. So protection starts running from there. It lasts for 20 years. However, for that 20 years to keep running, the patentee must pay an annual fee. Otherwise, the patent will lapse. What that means is that it falls outside legal protection. Okay, so it lasts for 20 years, within which period the patentee must continue to, if you like, service it by paying the annual fees. And the fees, obviously, is determined by the CIPC. Information can be obtained from the CIPC's website. So if there's an infringement of your patent, you simply need to seek legal advice. The process would involve, getting remedy in court. And the courts established for this purpose is the Commissioner of Patents, which is occupied by a High Court judge, skilled obviously in the field of intellectual property. You can also approach the CIPC for guidance on what steps to take, in ensuring protection of, in seeking redress for infringement of your patent. Regarding patentee, legal advice for patenting, there are two ways you can actually seek legal advice. First, you approach an intellectual property firm. Alternatively, you approach the CIPC. The CIPC has a program called the Inventors Assistance Program, under which they guide inventors, assist inventors to seek, to grant, to obtain patent, also assist them in cases of a breach of or infringement of their patent.